Welcome to the Solution Nation podcast. My name is Sean Snowday, and I'm the president of Solution Nation. Solution Nation is dedicated to providing a platform for investors to learn about Israel's most dynamic public and private companies. We interview lead venture capitalists, Wall Street analysts, investment bankers, and managers of incubators and accelerators. Today's topic is international patent filing strategies, and our guest is Spaeth with DilworthIP. Now, filing patent applications around the world isn't easy or inexpensive. Patent applications have to be drafted, prior art searches performed, filing fees paid, translations commissioned. Small and innocuous errors can be not only costly, but catastrophic in terms of enterprise value diminution. Please remember that all content provided on the Solution Nation podcast and website is for educational purposes only. Nothing shall be construed as investment advice. Investment decisions shall not be made based on information, written, verbal, or otherwise, posted or spoken on Solution Nation. Conduct your own research or consult with your own investment advisors before making investment decisions. So here's my good friend, the host of the show, and the CEO of Solution Nation, David Wanatik.
Hello, my name is David Wanatik, and I'm the CEO of Solution Nation. I'd like to thank you all for joining us. Today we have a very interesting session, very important session for particularly smaller companies that may not have the sophistication to orchestrate international patent filing strategies. That will be the focus of today's program, International Patent Filing Strategies. So I'm very pleased to introduce our speaker, Mr. Fredrick Spaeth, who is a partner at DilworthIP. Mr. Spaeth has been serving clients for more than 20 years in the areas of intellectual property law and commercial transactions, including preparing and prosecuting patent, trademark, and copyright applications in the United States and abroad. He's active in advising clients on questions about validity and infringement. He provides counseling in connection with the formation of R&D-based joint ventures, intellectual property licensing, patent landscape studies, brand protection and enforcement of trademark rights, and a variety of commercial transactions and agreements. Fredrick Spaeth has a very long and distinguished background, but perhaps I'll spare you of all the details so we can get into this very important and interesting topic of international patent filing strategies.
Thank you very much, David. That's very generous, very kind of you. I started off when you invited me to do this presentation. I came up with a list of the basic questions that came to mind that helped me talk with IP managers at my clients. And when having answers to these basic questions basically helps us to map out a strategy that aligns with the business goals for protecting and commercializing new technologies that our clients have. So the very first one, of course, is maybe the most fundamental, is whether or not to file. Keeping in mind that, submitting a patent application, the first step in the process, one of the first steps is having it published before it's even examined. So if the new technology is something like a manufacturing process that's used internally and that isn't evident from the end product, filing a patent application and having it published sometimes gives away the secret. Okay. On top of that, if competitors use it the same way as the client, that is, in secret, there's no way to detect infringement, even if it happens, and even if you get a patent. So that's a balancing act that clients have to go through. So balancing the trade secret, the value of keeping a trade secret versus a disclosure. On the other hand, a lot of inventions are become evident once they're commercialized, and then at that point, the competitors can easily skip over the difficult R&D that might have gone into developing this new invention, and have a very quick catch up, and that deprives the original inventors of a full return on their investment for putting in the R&D. So that justifies pursuing patent protection, and it's the basic incentive strategy that governments have for justifying patents in the first place. Okay, so when to file? There's two basic considerations here, but the main one is, and this is as much a legal call as it is a business call, because there are key, considerations on the legal side, because patents have to be based on inventions that are not already known in public. The comparison is what's called prior art, whatever the knowledge is out there previously, before the applicant has submitted the application. But this can include the contributions of the applicant themselves. In many countries, if the invention is released before the patent application is filed, the key qualifying aspect of the invention, which is novelty, is defeated. So for clients that are looking at global protection, we strongly advise filing first.
Fred, does that matter if we have an NDA? So let's say I have a great idea. I haven't filed a patent application yet, but I disclose my great idea to you, but we have an NDA. Does that affect the year that I have to file?
Yes and no. In a lot of the countries that have a absolute novelty rule, the NDA buys you time, absolutely. So they're very, very important for that aspect of it. In the US, there's a little bit different, because if you're commercializing the invention, even if you commercialize in secret, the NDA won't stop the clock ticking on what we call a grace period. There are a lot of countries that have this, with understanding that sometimes, an invention is rushed out to market. And in many countries, including the US and Canada, the patent laws allow for 1 year after the public disclosure for applicants can still file their patent applications. But keeping in mind that they will have defeated novelty in other countries. So again, that's another one of the balancing acts that you have to practice. All right, so I covered the grace periods, and I think we can go on. So once a decision is made that you've got an invention or innovation that's worthy of protection, and that patent's the way to go, what do you file? What do you file next? Provisional, non-provisional, design. Designs are sometimes a good option, sometimes overlooked. Recently worked with a client that had an add-on for cars in the automotive industry. And it was a high-tech add-on, but it actually got mounted on the outside of the car, and they had a great design for it. And while we were working on the utility patent for it, I said to them, look, you should really protect this design, because you're going to go to market. And this is the first thing that the buyers are going to see, and the first thing your competitors will see. So protect the way it looks with the design. However, the broader protection was deemed, that people think of as the broader protection, goes to utility applications. And with utility, you have an option to go with a provisional application for your first filing, or a non-provisional. The provisionals tend to be easier to file. They're not examined as closely as non-provisionals, if at all. But they do provide an early filing date, and that's the big advantage of them. In addition, once you file a provisional, you set a clock ticking. It's 1 year in which time you've got to file the related non-provisional application. The provisionals don't get examined the non-provisional will, and that kicks off the actual process for getting a patent. But in between filing the provisional and the non-provisional, it can be useful to file these incremental filings. So this is typically done when the invention they want an early filing date, but R&D is ongoing, and as the applicant discovers, more aspects of the invention, they come up with the new features and things, you just refile and add to the initial filing. You can do that all the way up in that 1 year, up to the point where you need to file the non-provisional. You typically can't do that with the non-provisionals if you start with one that way. The US has a kind of a practice called a continuation in part, which kind of resembles that process, but it's not something that you can do in many other countries. So the US is good for filing provisional applications, but once you go non-provisional, you're pretty much locked into whatever your disclosure is.
So, Fred, if the early priority date is important in filing that provisional patent application, how well drafted does it need to be? Should we spend pretty much the budget we were planning to spend on the non-provisional, pay you that money up front to draft a really, really nice provisional? Or, can we get the benefit of the early priority date if we're just file something pretty narrow, pretty skinny application?
That's a great question. Technically, the requirements for a provisional application are exactly the same for a non-provisional. When we work on provisionals for clients in our firm, we like to do as good a job as we can possibly do, understanding that the clients are expecting these to be done, more quickly and more efficiently and at lower cost than a non-provisional. And so we kind of run down the middle of that road. I have not seen a whole lot of litigation in which the difference between the level of preparation of a provisional versus the non-provisional that gets filed from it is challenged, but the potential is there. So again, we like to do the best provisional that our budget and time will allow.
And you made a good point about filing additional successive provisionals during that year from the time you filed your first provisional. So I do valuations, and it impresses me when I'm looking to determine the value of a patent family if there were a number of provisionals filed relative to the eventual issued patent.
Right, and so the provisional lets you do that. And again, once you file the non-provisional, if you're taking that forward internationally, you're kind of locked into that disclosure. I want to back up my slides a little bit. It seems I jumped. Okay, whether or not to file protection novelty. Okay, we talked about the grace periods, provisional, non-provisional. Okay, good. So the international filing, where's the first filing going to happen is typically in the country where the headquarters is located. What happens then? The first filing, whether it's provisional or not, gives you a priority date, and that sets a clock ticking. If you want to go abroad, you can save that priority date if you file within 1 year for a utility application. If you're looking at a design, that cuts down to 6 months. You only get 6 months to do that. And this is under an international convention known as the Paris Convention, which went into effect in the 1800s. But that 12 months can be a big burden, especially for smaller companies, considering that the cost of going into each country that they want to file in is going to be substantial. And thus the patent cooperation treaty system was invented. And under that system, within that initial 1 year, instead of having to go to all the countries you want to get into, you make one filing. And with that, all the participating countries will honor your priority date, your initial filing date, as long as you then proceed to do all their local requirements, including paying those fees, within 30 months from that initial priority date. So it buys you 18 extra months, during which, product development and getting customers and getting on market can happen. You can generate some income to finance these other filings. And it's a great tool. And the vast majority, around, last time I looked, I think it was about 80% of all filings that happen from one country to another are done through the Patent Cooperation Treaty.
How many countries are members of the PCT?
At last count, it was like 157.
Almost all the countries you'd want to file in. Are there any major countries that that are logical places to file in that are not part of the PCT?
No, every major industrial country with a decent economy is a member of the PCT.
Okay.
Yeah. Now the PCT structure works like this. There's the PCT system has what they call a receiving office. And a receiving office is a place where you submit the application in a form that's acceptable for the PCT process. And the office has to be equipped to examine these applications for formalities, and also to communicate well with the International Bureau. Many, if not most, of the participating countries also serve as a receiving office. So, for example, in the U.S. Patent Office is a receiving office. We can file our national applications here, but we can also file our PCT applications in the U.S. Patent Office. That gets communicated to WIPO, which then communicates with all the other participating countries.
So what is WIPO? What's the connection between PCT and WIPO?
Yeah, WIPO is the authority that administers these applications. So they set up agreements with the participating countries. Here's what you have to do to be a member of the Patent Cooperation Treaty, and here's how things go, and so on. Whether or not your particular country can serve as a receiving office or not, and what there's another office that's involved that gets associated with receiving offices, and that's called the International Searching Authority. And when applicants submit their applications, they choose not only whatever receiving office that they're going to use, but also they designate the searching authority that will look at the claims and find some prior art. Okay, so when you file the application that way, you have access to all 157 of the participating countries. So that's a decision that you don't have to make, in that first 12 months. And I'll mention this, it's a little bit different when you talk about international filings for designs. That goes under a different international convention called the Hague Convention. And the Hague filings, you actually have to go down the list and check off the countries you want and pay for those designation fees when you file. Now, those fees aren't quite as hefty as PCT, utility application filings. So I guess that's the difference there. And with your 12-month PCT filing, if you do have interest, if your client has interest in countries that don't participate in the PCT, you've got to file there as well. I don't think I've ever seen that, but you need to be aware of it, because once you lose that priority date, everything you've done, everything that gets published after that is potentially prior art, and can defeat the novelty in that country. We had talked about, the strategy of actually getting into the national stage in various countries. How do you choose? And so at the bottom of this slide, I put the basic considerations. You've got to look, clients got to look at where they want to do business and where their competitors are likely to do business and take away from theirs, whether it be by having a customer base there, or maybe that's where they would do their manufacturing. Okay, and they do a lot of heavy export from any particular country. So when you look at a list of the 157, you don't need to go to all 157. It's rare that all of them are commercially significant to your client. And there's also budget considerations, and especially with the smaller clients, I say, look, you can pick one or two or three. You've got the US, you can pick Europe as an entire economic region, and maybe one or two other big countries. And, if your patent's worthwhile and the invention's well accepted, you'll do well, and you can generate funds and maybe file more broadly later. You don't have to bankrupt the company on the first filing. Now we submit applications, and there are some limitations. When the applications get submitted and it gets sent to whatever searching authority you've designated, they will look at prior art and come back with a basic indication of whether the claims look like they might get patentable or be patentable or not. And there's the decisions on what to do about that. If it comes back with a decision that says, it looks like it lacks novelty, or maybe it lacks an inventive step. In other words, the claims seem to describe something that would be obvious to one of ordinary skill in the art. Sometimes, depending on how aggressive and how thorough the patent attorney is in drafting the claims, the searching authority will look at it and say, you really asked us to search more than one invention here, and you only, for the basic filing fee, you only get a search on one invention. And they'll set aside some of the claims on a theory that they call, lack of unity of invention. Now, in the PCT, you get the option of, paying for a further examination at that point. Something similar will happen in the U.S. national stage. We call that a divisional requirement. But in the U.S., you don't get to examine those same claims in the same application. You've got to refile the application and separate out the claims to the second or third invention, whatever that is. If the searching authority comes back with an opinion that says, we don't think that the claims define patentable subject matter, this is a determination that's not binding on any of the participating offices, but it does carry persuasive weight. Okay, so initial decision to be made at that point is, what do you do about it? The PCT system lets applicants respond to the search reports by amending the claims. So if maybe they came up with prior art that wasn't foreseen, and you look at the invention, you look at this prior art and say, we can change the claims and get around it, and you can do that and submit those revised claims, get that attached to the application, and so that will go to the national stage with increased chances of getting a patent in all those countries. So on the other hand, it can be an all or nothing kind of a bet on those revised claims, because if you can put them in, you can either decide just to submit those claims, the revised claims, and let them go to the national stage and argue at each country, that, we think those revised claims should be patentable even over the prior art in the search report. Or you can submit arguments to the PCT searching authority and ask them for a further examination in what's called Chapter 2. But that can really be, sort of a big bet, because if you submit your best claims on the international stage and the examiner there is still not convinced that it's potentially patentable, that message goes out to every country that you want to go into. And, you might have a really hard time, getting the claims that you submitted at the international stage, unless you further amend them and make them even more narrow in the national stage. On the other hand, if you succeed, again, these opinions at the international stages they carry persuasive weight, and you can do really well. It provides a really good outlook and will justify spending a lot of money on national stage filings.
That's a good point. So I think it would be helpful maybe just to walk through a scenario. So if you don't mind, let's say that I come up with an invention today and I have you write a provisional patent for me today. We file it today, let's say. So I have 12 months to file a non-provisional in the US, or I could file it outside of the US, correct? Under the PCT?
Yes, absolutely.
Okay. So what are the pros and cons of filing first in the US or first in PCT and then the second one in the other region?
Yeah, one of those has to do with basically getting some feedback on the examination process. The PCT authorities tend to have a tighter deadline for doing their searches and coming out with some kind of indication of whether the claims are at least novel. And it can take longer at the US depending on how backlogged the US Patent Office is. And since the US is a participating country, you could skip over your initial filing of the non-provisional in the US, just file the PCT off of your provisional, and then enter the US national stage 30 months later. On the other hand, the US Patent Office does have a provision for expedited examination. It costs a lot. So sometimes it's more cost efficient to go on the PCT schedule, if you will.
So when you file with PCT, they have one of the authorities can start conducting a search pretty soon, prior art search relatively soon. Okay. And then the examiners are actually employed by the PCT? Yeah,
I don't know exactly what the employment is, but I expect it's by whatever national office has been approved to be a PCT search authority. There are lots of them. And you do have an opportunity to choose which one you want to go to. Among the top 5, they handle at least like 80% of all the applications filed in the world under the PCT. And I actually have a little bit of statistical information I pulled out on that. Let's see. Well, there was the top 5 were, I think, were Europe, Japan, South Korea, the US, and China. Okay. And among those, Europe was the big winner.
As far as conducting searches, you say, or?
As far as being the choice of applicants to be a searching authority.
Okay. All right. So the PCT, you file the PCT, you pay a fee. One of the searching authorities that's contracted with PCT will start to do a prior art search. When you submit an application to the PCT, does it have to be in multiple languages, or is English sufficient?
Yeah, there are languages that are required. the PCT application gets published for international viewing. And there's a limited choice of languages that are required there. But almost all of the receiving offices let you file, in the application, in the language of the country where you file. So, people in, I don't know, let's say Bosnia, they can file in Bosnian language, but they would be required to submit for publication purposes a translation into
one language, into one language, or into multiple languages. And I think English, French, and German are the main ones. But
yeah, English is one of the official languages. I think Spanish is. I think there are three, and I'm not sure aside from English.
Yeah, French and German maybe. So you just have to file in one of those languages, not all three of those. Is that correct?
Right. I mean, from the U.S. perspective, filing in English is all you need, because English is one of the required international languages.
Okay.
Yeah.
And then how would you characterize the rigor of the examination, I guess, after the prior art searches, under PCT auspices or at the USPTO?
Yeah. Again, one of the reasons why, for example, Europe is the most popular and why the Big Five are the Big Five is because the searching authority staff are so well equipped and well trained. It's the same people that would file, that would examine, European patent applications or U.S. national file patent applications. Very often, I've seen PCT filings in the U.S. that went to a U.S. Searching authority examiner in the U.S. Patent Office. And then when we got to the national stage in the U.S., it was the same examiner, and so the conclusion that they came to at the international stage, at the PCT stage, of course, is very convincing to that same examiner in the national stage.
Okay.
One of the other considerations that some people strategize over is how fast these offices work, because it's good to get feedback sooner rather than later. And for that, I'll mention the fact that WIPO actually keeps a scorecard on all of the searching authorities, and they publish a report every year. And you can go online and find this. So if that's a concern, you can be selective about who you choose.
Okay. I've heard that maybe the European examiners are more rigorous than the U.S. examiners. Being an examiner in Europe is more of a career decision. You stay there for longer, and compensation is very good. And I think you have to be fluent in at least 3 languages to be a European examiner. I'm not sure that's the case in the U.S. When in the U.S., a lot of examiners they end up working for a law firm later. They leave after some years. So is that thesis? Is there merit to that thesis that the examinations are maybe a little more rigorous, and therefore, if I'm looking at a patent, I would be more impressed if it was examined by European examiners than the U.S. examiners?
Yeah, Dave, I think you're right about the difference just in the nature of the career paths for examiners in the U.S. and in Europe. The standards against which the international examination is done, they're expressly not the same as the national patentability, which is why the international authorities are not binding on the national authorities. So that being said, one of the considerations of choosing a national stage to go into is the local laws on what's patentable and what's not. In the U.S., for example, software inventions are a lot harder to get patented, even if the international stage examiner says it appears to be novel and non-obvious. you might have a harder time in the US than you might have in Europe or Japan, for example.
So you pay your fees, you have the search done at the PCT, examination starts. At some point, the examination is over, right? With what, 18 months or 20 months? Something like that, maybe.
Yeah.
I guess first, what happens with publication? What point does it become published? And then, even if the examiner at 18 or 20 months says this is a great application, we're going to issue it. It's not really issued in any country at that point, right? Because you have to make a national phase election.
Exactly. Yeah. The international, the PCT publication of the application is just a published patent document, but it's not a patent.
Okay. So, like in the U.S., applications are published usually 18 months after they're filed. Is there a time period at what point the PCT publishes applications?
Yeah, the PCT, and in fact, I think almost every national country follows that same 18-month rule.
Okay.
And they've, again, the WIPO published statistics about it every year, and they're pretty good. Like within month 19, everything gets published.
Okay, so if a client has some published applications at the PCT and the bill of health is very good at the PCT, and they're going to file in 17 of the member countries, is it safe to say that most of those are going to be just rubber stamp prosecutions in those 17 countries because they respect the authority of the PCT, or is there more rigor to those national phase examinations?
Yeah, the idea is that the international stage authority saves the work of doing searching and examining at the national stage. So a lot of the times, if you get a favorable outcome, at the PCT level, things are looking pretty good almost everywhere you go. It's on the unusual side for national patent examiners to, go the other way. But that can happen sometimes, if the examiner happens to be aware of prior art that the international authority missed, or if, it's the nature of this invention is something that simply doesn't work in that country. Like I mentioned, for the US software, diagnostic testing on the medical side can be more difficult in the US than elsewhere. And business methods, don't fly in the US.
Mm-hmm. So let's say that I file my PCT application in English, and I want to, and it got issued, and everything is good at the PCT. I want to do a national phase filing in Sweden, Bulgaria, and so forth. Do I have to pay to translate into all those languages, or do all those countries usually accept one of the primary languages?
That's a great question. One of the big costs that gets deferred through the PCT is having to submit translations that match the national requirements in all the countries you want to go into. That's why that extra 18 months it's so useful. You're able to make good decisions about whether it's a good investment or not to get those translations.
Does the PCT charge annuities, or is it just the national phase countries that charge annuities?
Yeah, no, the PCT does not have an annuity or maintenance requirement. That happens at the national stage. Okay.
So you pay your fee up front to have your application reviewed at the PCT, and you can just sit there for a year or two after it's been issued at the PCT without paying any extra money until you go to the national phase.
Right. I mean, actually, a PCT application really, I mean, from a practical standpoint, has limited life. It's based it starts with the priority date of the application that you're relying on. It might be your provisional or it might be your national utility application. And then you've got the 30 months of that whole time when all this examination of the claims happens and everything. And at the 30-month mark, sometimes 31, you have to file and enter the national stage in each country. At that point, the international application itself is just a piece of publication that's out there. It has the life has ended. There's nothing more to do with it.
Mm-hmm. Isn't there something that if sometimes back fees could be payable for annuities after the patent is issued in Europe? So let's say it goes through the PCT, we use all of the 30 months and we file in Romania. Let's say it takes a year for the Romanians to approve the patent application. There's no like backward annuities. I've heard of such a thing. Maybe I'm not giving the right example. Yeah,
I don't know the details of how the EPO or the European patent system works on that. I mean, as I recall from some direct European Patent Office filings that we've handled, that can the maintenance fees, the annuities, trigger off the filing date. But I don't know how I honestly don't know how it interacts with the PCT filing dates.
Okay. And then like the EPO, is that like a supranational body for the European countries? So you go to PCT and then what's the interaction between PCT and EPO?
Yeah. So the European Patent Office is authorized by the countries that participate in Europe, which is, again, most of them, who designate that office with the authority to issue a patent that can be enforced in all those countries. So rather than having to file in Germany and France and Spain and so on, and Luxembourg and so on, you file in that one European Patent Office. They carry out the examination and they can grant a patent that can be enforced in all those countries. You do have to pay a fee to sort of what they call register the patent in those countries. But overall, it's a savings. If you have more than, say, 3 or 4, more than a handful of European countries where you want to do business, you save a lot of money by filing in the European Patent Office and letting them make the determination.
Mm-hmm. Well, one could go directly to the several countries they want to file in, right? You don't have to go through the PCT. You could go directly, right?
Yeah, you absolutely could. But then again, you're scaling it back to the 12 months from your initial filing if you want to preserve your filing date.
Okay. So that's a big disadvantage. Are there any advantages of going directly to the 2 or 3 foreign countries that you want to get patent protection in?
Advantages to direct filings?
Yes.
I'd say the only possible advantage would be that you don't have protection in a country until that country grants a patent. And if you have a need for speed, the PCT is a little bit slower, actually. And there's also a patent prosecution highway that countries participate in. So you can file, for example, in the US and maybe pay for expedited examination, and hopefully it comes out favorably. And then the participating countries, maybe you only have 1 or 2 where you want to file, but if they're participating in this patent prosecution highway, they'll adopt the search efforts of the US examiner, or vice versa, depending on which way you want to go. And that speeds things along considerably. So I would say the advantage to going directly to national stage could be one of speed, if that's a concern.
Okay. And like in the US, one can seek interviews with the examiner. Can one seek interviews with examiners at the PCT? or national phases? Is that common outside of the US?
Yeah, I've never heard of a PCT examiner interview. That's a really great question. Certainly at all the national stages and in the European Patent Office, absolutely. But I've never had that come up in the PCT. I don't think they do it. I don't think they do it.
Okay. Wow. So I guess the big takeaway is this is very complicated. Patentees, especially people from smaller companies, have a lot on their minds, and patents is only part of what's on their minds. And this gets very complex very quickly, and you really do need to go to an expert like Fred Spaeth to help you with this. Somebody who already knows all the rules. You don't want to have to go through this learning curve by yourself.
Right. And when it comes to the transition to the national stage, we have existing relationships with law firms that have lots of experience in this all over the world. So we can go step by step and make sure everything that goes as well as it should.
Yeah, that's a good point. So going to a firm like DilworthIP, you have the relationships. I'd imagine for the translators, for the foreign attorneys all over the world that can make sure the foreign filings are going apace. And there's a lot that could fall through the cracks. So it's probably not safe for an inventor or entrepreneur to try it himself. Having somebody like you can manage the whole process and actually save money. But I'm sure you probably have better rates than I would get if I were to try to have somebody translate my patent into Romanian or have you.
Yeah, and in fact, again, it's a question of knowing who to go to. There are specialists that who specialize in translating technical documents for patent purposes, as opposed to someone you might just find on the internet.
Yeah,
we have people we work with.
Well, great. So Fred Spaeth, we really appreciate your spending a lot of time with us and educating us as much as possible. This is a very difficult subject, but you did a great job explaining this and answering all my questions. Hopefully I didn't annoy you too much with all the questions. But we'll make your contact information available, and people that need assistance with a international patent filing strategy, feel free to turn to Fred Spaeth and his colleagues at DilworthIP.
Thank you, Dave. This has been a pleasure, and it was an honor. I'm really pleased and flattered that to be invited to talk on your podcast, and we'll be happy to help out anyone that comes to us with the questions on this.
Great, thank you.